Hi everyone, welcome to Fact Friday. This week I'm joined by a very special guest in Alexandra Gordon. Alex is a solicitor and partner in our private client department. Previous Fact Fridays have been about lasting powers of attorney and mental capacity. This week we are turning our attention to wills, in particular executors, and what is an executor. An executor is a person that's legally appointed through your will to act on your behalf when you have passed away. Their responsibilities include collecting in all of your financial assets, paying out any debts, gifts, or tax due at the date of your death, and then distributing the pot left over, which is known as the residue, in accordance with your will. A interesting fact is around 50 to 60% of the adult population in the UK do not have a will. Alex, I do have a couple of questions which I've been asked to ask, but before I ask you these, do you just want to add anything to that?
Yes, thank you, Michael, and thank you for having me today. Um, it is really important to put a will in place because if you do that, you get to choose who your executors are. If you don't have a will in place, then administrators are appointed, and that's done in a statutory order. So if you want to make sure the correct people are appointed to deal with your assets, you must put a will in place.
Excellent. Thank you very much. Now, the first question I've been asked to ask comes from one of my colleagues in our conveyancing department, and this is, can an executor also be a beneficiary under the will?
Yes, they can. And it's quite normal that they are. So, for example, in your normal standard basic wills for your 2.4 children family, everything is normally given to the spouse and then on to the children, maybe at a specific age. In that instance, and if the estate is simple, normally the spouse is the main executor with the children being replacement executors. So, absolutely fine for a beneficiary to also be an executor.
Excellent. Thank you. And the second and final question I'm going to throw at you, Alex, is, can you appoint professionals to be your executors?
Yes, you can. So, with executors, they can be friends, family, beneficiaries, and also professionals. Most firms are now set up with what's called a trust corporation. So, you would appoint the trust corporation rather than an individually named partner. Now, the benefits of that are that the trust corporation is always going to be there. It's not going to retire, pass away, maybe lose capacity like an individual partner could do. So, it just means that you've always got someone there to act should anything happen to you. The only drawback, obviously, is that professionals do charge for their services, and most firms like ours, we charge on a time spent basis. So, whatever work needs to be done, that is all we charge for. We don't charge an uplift for acting. So, it really doesn't matter on the size of your estate, it depends on the complexity within it.
Amazing. Thank you very much. Now, if anyone does have any questions, please do pop them in the comment section below or drop either Alexandra or I an email. Next week, we'll be staying with the concept of wills. However, in particular, guardianship clauses within your will. So if you do have any children that are under the age of 18, this clause would be extremely useful to you. Any questions, please let us know. Hope to see you all soon. Take care.